Last night, in his remarks at his golf club in Bedminster, New Jersey, former President Trump, of course, offered political commentary and rallied the faithful, but he also started to advance a legal argument that one can only assume is foreshadowing of what his attorneys will present in court, at least in part. And the legal argument he made is essentially that the Presidential Records Act is controlling on this matter, and not the Espionage Act, and that he had every right to take the documents that he took and keep them. And Michael Bekesha agrees with him. Bekesha is an attorney for Judicial Watch, writing in the Wall Street Journal about his experience on topic. He was the lawyer in the case that was cited by Trump, the Bill Clinton sock drawer case. He was the lawyer arguing for the release of those Clinton tapes, that Bill Clinton did not have the right to keep those tapes, which included calls with legislators as well as senior level staff like Secretary of State Warren Christopher at the time about matters that were geopolitical. One was about the NAFTA agreement. Another, the conversation with Warren Christopher about a diplomatic impasse in the Balkans. Another on foreign policy decisions such as military involvement in Haiti and possibly easing the embargo in Cuba. He wanted the Clinton tapes. And Mr. Bekesha writes that the Presidential Records Act allows the president to decide what records to return and what records to keep at the end of his presidency, and the National Archives and Records Administration can't do anything about it. I know because I'm the lawyer who lost the Clinton sock drawer case, as I said. We sued in federal court and asked the judge to declare the audio tapes to be presidential records and, because they weren't currently in the National Archives' possession, compel the government to get them. The Justice Department at the time argued that National Archives does not have a duty to engage in a never-ending search for potential presidential records that weren't provided to National Archives by the president at the end of his term, nor, the department asserted, does the Records Act require National Archives to appropriate presidential records forcibly. Doesn't require. It leaves them some wiggle room. The government's position was Congress had decided that the president and the president alone decides what is a presidential record and what isn't. He may take with him whatever records he chooses at the end of his term. That's the interpretation. Judge Amy Berman Jackson in the case agreed, saying, quote, since the president is completely entrusted with the management and even the disposal of presidential records during his time in office, it would be difficult for this court to conclude that Congress intended that he would have less authority to do what he pleases with what he considers to be his personal records. Judge Jackson added that the Presidential Records Act contains no provision obligating or even permitting the National Archivist to assume control over records that the president categorized and filed separately as personal records. Now, therein gets some of the details. Was what was in Trump's possession categorized and filed as personal records? Were they personal records as opposed to records covered by the Espionage Act? Do you have to declassify in order to turn classified records into personal records? Can you even do that? Or is it something where you have to generate the record the way that Clinton did with the audio tapes, even though it was a matter, these were recordings of the people's business? We talked to Andy McCarthy about this specific case on Monday, and he seemed to say that he didn't believe this was a compelling defense, that it was not on point. But it's an argument that is being advanced by Trump with some help from lawyers like Michael Bekesha. So let's get another opinion on this. Pleased to be joined by Professor Richard Epstein, who's the James Parker Hall Distinguished Service Professor Emeritus of Law and Senior Lecturer at the University of Chicago. Professor Epstein, thanks for joining us. Appreciate it.
Well, I would like to say it's my pleasure, but under these circumstances, I'm not so sure.
Well, yeah. Well, what
You know
about
what's going on.
this matter of the Presidential Records Act versus the Espionage Act? Are they at odds? Does the latter preempt the former?
Look, I'm going to start, first of all, with a very simple observation. Judge Jackson, she's an able judge, but she's a lower court judge. It's not a binding precedent on anybody in another district, and certainly on an appeal, it's just something to be taken into account.
Hmm.
So there's nothing which says that the opinion is necessarily right, although it would be remiss from not to rely on it since it is authority on the book. I read that column just about 10 minutes before I got on this show, and my great temptation was to try to go back and read it to parse. But I'll give you that kind of following off-the-cuff reaction, which is going to be subject to a lot of qualifications going on. There's something vaguely odd about this. We put together this whole act about national records. I believe it was in the aftermath of the situation in Watergate when Nixon tried to do the same thing. And so she says, in effect, that the act is only binding on the president if the president chooses to bind himself. And then she further says that if you take these particular documents and put them into your own possession, no matter what their content, there is nothing that the government can do other than to ask you to return them and to give up if you decide that it's not. Well, this makes the statute rather toothless, don't you think? I mean, we clearly had an abuse of presidential power back in the 70s that we were trying to correct. And then you see somebody saying, well, there's nothing we could do about this at all. So that's the first point about what's going on. It strikes me as being, as having the wrong resonance.
Well, but let me just ask a question about that.
Sure.
That may be the case. That may be the case. That's right. It's an odd interpretation, and that it doesn't provide much enforcement power for the federal government with respect to records.
Yeah.
But this was right. As you say, Presidential Records Act was enacted after Watergate in a response in part to Watergate. And if Congress intended it to be a civil matter with limited enforcement power other than persuasion, well, that's what they intended.
If they intended that. So what I said is the reason I wanted to go back to the statute was to give myself an independent read. But now let me make a second argument. What happens is the strength of this Records Act is that most of the president can keep the documents. But in the Clinton case, we have to ask whether or not he released or paraded them around to anybody else, whether he put them in circumstances where they could be compromised. And I think in that case, the only issue was, can you keep them or can you not? I don't think there was anything remotely analogous to the allegation that he took some secret war plans and waved them or showed them, we don't know which, to somebody sitting there in Mar-a-Lago. And so the question is, if you look at all of the behavior that is charged against Trump, the hard issue, and I can't give an opinion on it, but you got to ask it, is the opinion of Jack, is her opinion going to be able to govern every act that was charged in this particular indictment? And the answer to that question, I think, is still very much in there. I am a law professor. I'm supposed to know the answers, but at this point, I'm not even sure I know I'm not even sure that I know the question. We've never been here before. We've never had a president who's so bizarre and self-destructive. There was not a single commentary that I read amongst the serious kind of Eastern press and even the Midwestern press, which sort of said, this man is exemplary. He did such wonderful things on January 6th. He took great care of these documents. He's been scrupulous. The arguments against him is that he's guilty not only of this, but everything that happened from the time he ran for the presidency in 2015. I don't like those kinds of arguments against him. The other part of this thing, which is very disconcerting, is the way in which the comparisons to Hillary Clinton and to Joe Biden and to Hunter Biden are made. Those guys have all gotten the benefit. Bret Stephens, who hates Trump, all right? He says the alleged kinds of misconduct by Hillary Clinton. There was nothing alleged about this. It was clearly established she used an illegal service, and that Comey let her off because of bizarre reading of what's the mens rea, that if the mental state requirement is, all you need to do this as a crime is to prove that she had those things in her possession and put them on an unauthorized server. You don't have to prove that she thought it was unlawful. And that was the kind of talk that he started to get. So you bring that forward to this case. Well, Trump has really asserted this under the NARA Act. Well, he basically thought it was lawful. We shouldn't publish it at all. Then there's the fact, well, we really have to run an investigation of Biden in Delaware. The president's kept his hands out of this. We have no idea whether or not he wants his son to be indicted. I say that tongue in cheek. And that investigation started before and will never end because they removed some of the key operatives on the case at the order of the FBI and so forth. And so what's going to happen is when this thing gets into the public domain, as it surely will, it's not going to be just about the technical issues of narrative, which are very sound issues, I might add, to raise them. It's also going to be the question about equal justice under law, because there are two elements here that one has to remember. Everybody says nobody's above the law. That's fine. And then it turns out selective prosecution is also a very bad thing. And so what we do is we have the argument that this is selective prosecution against Trump because everybody else is getting off or has gotten off easily. That the entire Democratic administration that had hounded him when he was president and afterwards really made such bogus charges that we can't go after him now. It's just a continuation of a vendetta. While their people sit fat, rich, and happy. This is, to me, the most corrosive public debate that you can have because the necessary effect of it is it takes our two front runners, neither of whom should be president under any circumstances. And what you do is you see each of them defaming the other, meaning that no matter who wins the election, he's going to be severely compromised when he gets into office. So this is an absolute national tragedy of the first order. What Trump ought to do is to simply pull out of the election. I have a great deal of hope that I can persuade him of that. And what Biden should do is announce that he's not going to run for re-election.
Right.
Well, neither of those things is going to come to pass, it would appear.
So, Richard Epstein, I wanted to ask you about espionage because the crime of espionage, you have to prove that harm was done. Was there any harm done to the country or to any said people by what he did?
I love what, you asked exactly the right question. Is the definition of harm a proof that some of the information that you obtained was passed on to somebody else and we know who got it? Or is it a harm to say that there's a substantial risk that things could have happened given the way the situation was organized? And I think it's got to be for the definition of harm under this. You have to take a somewhat broader definition. But then that gets you back to the same problem that we started to talk about at all. Do we know who stole anything from Hillary Clinton's homemade server? The answer is we do not. But if you have 30,000 emails on a machine which is rickety and utterly unsecured, the presumption is going to be that somebody got something somehow. And if that's the case, is that presumption enough to satisfy harm if you have a prosecutor with the same kind of diligence that Jack Smith brings to this case? I think the answer to that question is yes. Now, you start going into the stuff that's in Mar-a-Lago. This is not online. There were not 30,000 emails that were deleted in the pursuit of this particular case. There's no evidence that anybody broke into the room. And then to just put it further, for playing the espionage game, Joe Biden kept a bunch of stuff in the garage. He said, well, I returned it when it was asked. That is correct. And it's a difference, but it's not necessarily an on and off switch. The proper answer would be, well, you took this stuff, you're in violation of the espionage, you gave it back. So what we're going to do is when we determine sentencing, we're going to give you a mitigation factor that we've denied to the president.
Exactly.
And the way in which well,
but we have to send out an FBI team to find the special counsel on the Biden classified docs case because nobody's seen or heard from Robert Hur since he was appointed.
Yeah, I mean, what it is Biden. If this is if it's an offense by Trump to do what he did, it's an offense by Biden to do what he did, and then in the sentencing, you take the fact that one cooperated and the other did not. That's a much more sensible reading of the statute than to say that when you return stuff which you should have never taken in the first place, depending on how you read NARA and so forth, that's a complete defense of what's going on. Now, Pence may have a stronger defense on this because he may not have known what was in the particular boxes in this particular case, and it would be a question of mental state as to whether or not Biden knew what was in those boxes. But the presumption, I think, is going to be in both of those cases, maybe of different strength depending upon the factual pattern, that they knew something that was there. And so then that gives you the question of what counts as knowledge, Amy? And this is a lawyer's question. Is it constructive knowledge? And you say, what do you mean by that phrase, Professor Epstein? Well, constructive is a word that lawyers use all the time. Constructive possession, constructive notice, constructive this and that. What it means is you have enough information in your hand that if you conducted the simplest of investigation, turn over the rock and see the termites that are lying under it, then you know what the ultimate situation turns out to be. And that can be used, I think, in criminal cases if you can prove that the gap that you have between what you did and what could have happened to you is one that you could easily overcome. And in the Clinton case, I think it's a virtual certainty that somebody spied on her. And I do not expect the people who spied on her to come forward and say, well, we spied on Mrs. Clinton. Because then they're going to put themselves in trouble and they're going to compromise the information that they got. And
Right.
so I think, in effect, all of these cases have shades and nuances amongst them. And the way you have to think about this as a lawyer is if you look at them from 1,000 feet up in the air, they kind of look the same. But the moment you get closer and closer, then subtle differences amongst them appear. But those are not black and white differences. You say this one's off, that one's in the case. They're exactly the opposite.
Right. So, yeah, right.
Mitigation.
But this is what's going to happen. You're going to have lawyers in the public arena and probably in court are muddying the issues of willful and constructive knowledge and gross negligence, and ultimately making, I think, a normative argument, a policy argument about equal justice before the law and the equal application of the law. And that's where Trump's best chances lie, it would seem to me.
I think they lie in the political arena. I think the fact that you prove that somebody else was under-prosecuted is not itself the key for the kingdom. But in the political arena, he's very good at playing the hopeless victim who's been beaten up by everybody else. And to his side, I think that many of these investigations that were made of him were just absolutely unprincipled, and they were done in the worst possible way. And I think that Biden and the Democrats were behind them. So I don't have any sympathy for them. I think there's a Shakespearean phrase which captures my vote. Do you know what it is? A plague on both your houses.
Yeah, okay. How about I'll respond with from measure for measure. Some people by vice do rise, and others by virtue fall. How's that?
Well, I mean, no good deed goes unpunished.
Okay, all right. The cliche contest with Richard Epstein.
We're a massively literary team.
Richard Epstein, James Parker Hall, Distinguished Service Professor, Emeritus of Law, Senior Lecturer, University of Chicago. Professor Epstein, always a pleasure. Thank you.
Take care.
Thank you. And he joined us on our turnkey.pro answer line.
It's like a hot, steaming cup of information to start your day. It's Chicago's Morning Answer on AM 560. The Answer.
If you have unfiled taxes or are in debt to the IRS, this is important news. The IRS just rolled out a new program to help struggling taxpayers more easily resolve their tax problems. It's called the